Director of Banca Intesa Sanpaolo SPA and Venezia.
Good morning, my lord.
Yeah. We would like to look at the judgments in
I was.
Bank of Greece.
So we're in the Authorities Bundle, Volume 2, Tab 15. And just to remind the court, the case concerned English law bonds and guarantees issued by the National Mortgage Bank of Greece and guaranteed by the National Bank of Greece. And your lordship will remember that there was a question about an old law being passed and whether that then removed the effectively transfer of the rights and obligations to the new bank.
Yeah.
And I was just about to turn to Viscount Simmons' judgment on page 272 of the report, which is at 517 of the hard copy bundle and 523 of the electronic, assuming 1 out of 6. And the starting point is that the judge sets out at the bottom of the page what Lord Justice Morris, delivering the Court of Appeal judgment, had said, and this of course was overturned, but that was the principle of basically you rely on Greek law as you find it, and therefore Greek law has to be taken on the basis it can give and take away, essentially, and that of course is similar to Venice's position on this appeal, because it's said by Venice, Italian law governs the question of capacity and that Italian law can therefore take it away. Very similar submission. Now, if we go over the page, please, and pick up at the end of the first paragraph, which starts, but if I say the end, it's about 8 lines up from the bottom of the first paragraph.
Sorry, which page number are you on?
It's page 274 of the report.
Thank you, got it.
274.
And that's 519 of the hard copy and 525 of the electronic.
Oh yes, but if I say that from the
Exactly, but if I say that from the moment, and if you could please read that to over the page at the end of the very first paragraph over the page, which ends with contractual rights. So 2 important points arise from the passage. First of all, the judge considered the effect of the 1953 law as a matter of fact without reference to the subsequent enactment. So in other words, he asked himself what the position would be if the banks had enforced their contractual rights between 1953 and 1956. The new law having been passed in 1956. The second point is that the judge was not very impressed about the debate as to whether the 1956 law should be seen as a law affecting the status of the bank or the law relating to the discharge of contractual rights. His approach was to look at the effect of the law as a matter of substance. And if we then pick up from the next paragraph, which is, my lords, I must notice at this point. And if we could read just that paragraph up to the end where it finishes with Greek law. And then in the following paragraph, the judge considers Lynch to have been correctly decided, noting over the page that it was followed and applied in the case of Ray Marshall, which you see in the middle of the paragraph over the following page, and that is, of course, a decision of the Court of Appeal. And the judge also applied Lynch by analogy to the facts before him.
Mm-hmm.
We then move on to the judgment of Lord Reed, please, picking up of the law report reference at page 281 in the middle of the page, and that's 526 of the hard copy bundle and 532 of the electronic.
It follows that before you.
Exactly. And if you would please read that to the end of that paragraph, finishing Old Bank. And I pause on the words, it is well established that the English courts cannot give effect to a foreign law as discharging an English obligation to pay money in England. Now here, the Greek bank was relying on a rule that the questions relating to the bank's status as universal successor are governed by Greek law, not English law. And that's why I highlighted Viscount Simmons' approach as going to the substance, not form. And here, and I make this point because I think my learned friend relies on this, Lord Reed distinguishes Lynch, but he doesn't do so on the basis that the decision wasn't correct on its facts. What he says about Lynch is that the Greek law was best characterised as a law which purported to discharge an English law contract rather than as a law which went to the status of the bank. So that was his approach. Whereas the majority of the judges here take a broader approach, as you saw with Viscount Simmons saying it didn't really matter. But what you don't see in this judgment, and we can go on through it, is any doubting of Lynch. So the principle I showed you from Lynch is something that all of the judges regard as properly decided. And if we go to the last paragraph of the law report, page 282, which starts with the effect of law number 3054. And we move down that paragraph. As I've already said, this is about 5 lines up from the bottom, as I've already said, it is well settled that English law cannot give effect to a foreign law which discharges an English liability to pay money in England, and the appellant's contracts were English contracts under which they were paid in England. So unless the form of a foreign law is more important than its substance, the relevant law must be treated as a law which seeks to discharge English liabilities, and it cannot therefore be effective in England. In my judgment, we must look at the substance and effect of a foreign law, and that is a question of fact. And then if you could please read the following paragraph, which I place some reliance on, about retrospectivity and the British Parliament being legally omnipotent in this country. So
He's really deciding it on the basis that there were in the period between 1953, the creation of the new bank, and the subsequent law in 1956, there were accrued contractual rights and obligations, and the foreign legislature could not remove those. That's effectively what he's deciding.
Exactly. You can't, English law is not required to shut its eyes to the fact that Italian law, as it stood when the parties signed the contract, clearly conferred capacity on Venice to enter into those contracts. And thereafter, there were English law rights acquired, which cannot be now ignored and removed. If we then go to Lord Radcliffe's judgment, starting on page 283, the same page, and again, this is a very short judgment if you could read it, but again, Lord Radcliffe endorses Lynch. And similarly, Lord Tucker, if one casts one's eye over that judgment, which is slightly longer, takes the same approach. Like Viscount Simmons, Lord Tucker did not think it mattered whether one characterised the 1956 law as a rule relating to discharge or to status, and he also endorsed Lord Penzance's reasoning in Lynch.
Yeah.
And you see that he says the present case is not covered by the actual decision in Lynch, but he applies it. And then finally, Lord Denning takes a different approach and refuses to apply the 1956 law because it was contrary to public policy. And he considered it was contrary to public policy for the Greek law to transfer assets to the new company, but to exclude liabilities. It doesn't matter for present purposes, except to note that even Lord Denning in that context cites Lynch without disapproval on the bottom of page 287 of the law report. So the case of Adams, we suggest, stands for 6 propositions. First of all, the question whether the new bank succeeded to the rights and obligations under the guarantees was to be determined by reference to Greek law as it stood in 1953 as a matter of fact. Secondly, under Greek law as it stood in 1953 as a matter of fact, the bondholders acquired English law rights as against the new bank under the guarantees. Thirdly, a Greek law which purported retrospectively to discharge those rights was not applicable. And the principle is a foreign law cannot retrospectively discharge an English law payment obligation. Fourthly, in order to determine whether the Greek law purported to have this effect, it is necessary to focus on the substance and effect of the Greek law rather than its form. Fifthly, it was irrelevant that any subsequent or the subsequent Greek law purported to remove those rights not by discharging them, but instead by altering the law of succession so that under Greek law the new bank never acquired the obligations in the first place. And sixth and finally, the reasoning in Lynch was approved by all 5 judges. 3 of them, Viscount Simmons, Lord Radcliffe and Lord Tucker, also applied Lynch by analogy when deciding the case before them. And we suggest these principles plainly apply in our case. And if I can give you a hypothesis, suppose in this case the Italian legislature had passed a law in 2020 which expressly provided that local authorities did not have capacity to enter into speculative swaps or swaps involving upfront payments. And this was supposed to have retrospective effect back to 2001. An Italian court sitting in 2020 would have concluded that the banks lack capacity to enter into the transactions, just as the Greek court in Adams would have concluded that the new bank never succeeded to the rights and obligations under the guarantees. But just as in Adams, the English court would not have reached that conclusion. And the question would have been whether the local authorities had capacity as at the time of the transactions in 2007, when they purported to exercise their power to enter into the contract. Because applying the ratio in Adams, the English court will not shut its eyes to the reality that they plainly did have capacity at that time, and from that point onwards, English law rights and obligations were taken away, and a subsequent law cannot take those rights away. And standing back, we suggest that makes complete sense in light of the unchallenged finding of Mr Justice Foxton under Article 3.3 of the Rome Convention, an Italian law which provided that these English law contracts were void would not have been applicable. So why should the position be different if instead of providing the contracts were void, the legislature retrospectively removed the local authority's capacity? Because in substance, they have precisely the same effect. And of course, I have been addressing the position with that example on the assumption we're concerned with retrospective legislation. In the present case, it was a judicial decision. And we haven't found any authority that treats a judicial decision in this way, but we would suggest the position must be a fortiori because it's widely recognised that judicial decisions have the possibility of being changed and are potentially less certain than a law. So in that scenario, it's even more the case for all the reasons I've suggested. But for present purposes, the analogy is that a retrospective judicial decision has precisely the same effect as the retrospective legislative change. In both cases, the parties' rights and obligations are altered. So for present purposes, there's no difference, but if anything, it makes even more sense that English law should not be shifting in the sands, as I said yesterday, on the basis of a decision that may itself change.
How is what happened in Cattolica different from a case where, for example, here the Supreme Court overrules a whole series of Court of Appeal decisions and gives a decision which is very surprising to everybody, which does apparently happen from time to time.
Well, indeed, my lord, but there are 2 points, aren't there? One is, first of all, and I couldn't swear to this, but it's difficult to think of an example of the Supreme Court retrospectively removing contractual rights by a decision.
Well, I think that's, I'm not sure about that. What about the recent decision in Packard? And the effect of that is that litigation funding agreements, which were thought to have been perfectly valid when entered into and have been performed and sometimes concluded, are now said to have been illegal.
That's right, my lord, although
So that's an example of retrospective effect.
but there are many, that's not a removal of capacity, there are many arguments.
No, okay.
And there are many arguments about that particular topic that might limit
Well, I know there are all
the
sorts of
scope of
arguments.
that decision. It's, and that's why it's not,
Just
I
sort of
was,
thinking aloud about
you're right to say that there's,
how we approach these things in this jurisdiction.
that's right.
Now, it seems to me, and thinking aloud really, which is probably unwise, there may be a difference between the effect of a decision of the Supreme Court in this jurisdiction, which has binding on all other
precedent.
courts, including itself unless overruled subsequently, and the decision of a foreign jurisdiction under the civil law system, which doesn't actually have precedential effect at all.
That's right, but there's 2 key points. The first is the one that your lordship's just made. But the second is here, the crucial thing is we're not in the same jurisdiction. So the whole ratio of Lynch and Adams that I'm applying is that the English court's rights and obligations can't be swayed by what's happening in the foreign court. So it may well be that the Supreme Court in England could make a decision and that has an effect on English law contracts. But what I'm suggesting to you is that here, what was regarded as the mischief was not what the Greek court was doing itself. And it was accepted that the Greek court would actually take the approach of not applying the new law and not allowing the rights and obligations to pass. What was said is, well, why should English law, where there are new English law rights and obligations, be affected by the changes in Greek law? And the ratio, it seems to me, is not just about the status of the bank, but the recognition that the discharge of English law payment obligations would be very serious as a matter of English law. And the reason I say it's a fortiori with a judicial decision, and the only reason it's relevant, it's a judicial decision rather than a law, because obviously an act of parliament could be passed here. But the reason it's relevant, it's a judicial decision, is because of my Lord Justice Flo's point. In Italy in particular, there's no binding system of precedent. So it's even more troubling for English law because the position in Italy could change. Catolla could be interpreted differently. So you're not even taking away the English law payment rights and obligations with certainty that that is what an Italian court would necessarily do or will always do.
Is there a difference between legislation and a judicial decision in this sense that the legislative decisions acknowledge that the law was X at the time, but it now has to be treated as Y, whereas the judicial decisions say that although it might have been thought to be X, actually it was Y all along, and people just had a wrong understanding of the law.
That's right, but for my purposes, on the judge's findings, the judge found that the decision in Cattolica was unforeseeable. And so this first point is, we would say it's not open to be, the other side to argue that Cattolica was some form of incremental development. That's point number 1. Point number 2 is, it doesn't really matter whether the Supreme Court said everybody misunderstood and that was the state of the law. In this case, and I don't have to put it wider, because your lordship has the legislation I've shown you with Decree 389 that bluntly shows it wasn't the case. So the Supreme Court may say it was always the case, but your lordship has got legislation that clearly states the opposite.
That comes perilously close to saying that Catholica is normally decided.
Well, my lord, I'm not making that submission for the purposes of this appeal, and your lordships don't have to find that. But there's no doubt that the reasoning in Catholica, in particular, of saying in relation, take for example, to upfronts, that the law was always the same, but ignoring the fact that the legislation was introduced in 2008 with the effect prospectively coming into effect of 2009, and there would have been no need for that legislation if the law had always been what it was suggested by the Supreme Court it was. And they said there was no innovation of the legal system. Now, there are points there that both Mrs. Justice Cockrell and Mr. Justice Foxton have highlighted are of concern to the English courts when trying to understand the reasoning, with no criticism of the decision, but it's not been done in the same way that perhaps in England it would be. That doesn't matter for my purposes. All that matters is that the judicial decision has been found as a fact to be unforeseeable and not an incremental development by Mr. Justice Foxton. And on that basis, if it was unforeseeable, it's a given that he found that the law was not the same until Catholica. And that's all your lordship needs for these purposes. And there is also a finding to that effect, were it to be relevant to your lordship, from Mrs. Justice Cockrell in the Busto case. And those are the two cases in the commercial court that have considered this decision. And I gave your lordship the references to that yesterday. I can find them again if it would be helpful. And just so, for my Lord Justice Mayall's point, we suggest that where the retrospective judicial decision is unforeseeable, there's no justification for treating that decision any differently from a retrospective law, and we support that submission in paragraph 108 of our skeleton argument by reference to the authority under the ECHR, EC treaties, and the Constitution of the USA. So I'll just give you that for your note. Now, can I turn then to Venice's authorities on this topic? And I'm going to take it lightly given time constraints, and I can come back in reply. But my learned friend's argument is that an English court will give effect to a retrospective law provided that the law is properly characterised as law relating to capacity rather than a law relating to validity of a contract. So even in the example of the retrospective legislation I just gave you, the hypothesis, my learned friend would contend that an English court must apply Italian law, including the retrospective change which revoked capacity, because capacity is governed by Italian law, not English law. And the short answer to this is that that would be a triumph over form, a form over substance, and is inconsistent with the approach I showed you taken by all of the judges in Adams and most notably Lord Reed. The argument is sought to be bolstered by reference to a number of authorities which are addressed in my learned friend's skeleton at paragraphs 91 to 95, but we suggest that they actually support my case. I can't go through all of them, but I have promised my Lord Justice Mayall's that I will go to Nelson and Bridgeport. So I will go to that one, which is in the first tab of the authorities bundle.
I think your enthusiasm for going to it was apparent regardless of anything I said.
I thought it was excellent, as you said, my lord, that there was still more relevant. So the authority stretches back to 1846 and was a dispute about succession to the estate of the famous Admiral. And the facts are incredibly complex, but I will just state them shortly, which is that Admiral Nelson's will provided that his brother was to inherit an estate in Sicily and thereafter settle it on trust. And if the trust had been effective, then the estate would have passed to the plaintiff. But under Sicilian law at the time, the estate couldn't be disposed of and settled on trust. And under Sicilian law, the brother succeeded to the estate, and thereafter it would have passed to his eldest son, or if no sons, to his eldest daughter. But during his brother's lifetime, Sicilian law changed so that his brother became absolutely entitled to dispose of the estate, and his brother exercised the power by making a will leaving the property to his daughter, the defendant. The wrinkle is she would have inherited anyway because the Admiral, Nelson's brother, had no sons, but be that as it may. The only question before the court was that the issue of whether the change in Sicilian law meant the original trust could be given effect, and then the plaintiff acquired the estate. And the MR rejected the argument because the alteration in the general law of Sicily did not have retrospective effect so as to revive and give effect to the trust. And you can see that from page page 11 of the bundle, which is paragraph 573, and you can see it's the paragraph just above 574 at the bottom of the page. So it will be 17 of the electronic bundle, I think.
574.
You see there's a paragraph reference in square brackets right at the
Yeah.
bottom. And it's 225 on the top right-hand corner of the report.
Oh, yeah.
So being one of the trustees of the will, he was bound to do all that he could to perform the trust according to the expressed intention of the testator, and was answerable in this court for any neglect of duty. But whether he did or omitted to do anything which by either law of England made him answerable or assets liable in this court under the law of election or otherwise is a question not now under consideration. And having regard to the law of Sicily, I am of the opinion that it is unfortunately contradictory. And if we go over the page, you see that the trustees named in the will had at the time of Lord Nelson's death no power or authority to make a valid sale of the estate. So emphasis being at the time of Lord Nelson's death. So the case says nothing at all about retrospectivity. It's not helpful to my learned friend. And on the contrary, the court applied the law as it stood when Nelson died. And it applied the later change in law from the point in time at which it took effect, not retrospectively. The next case my learned friend relies on is Phillips and Eyre, which I'm not going to turn up, but it takes matters no further because it's all about the law of Jamaica, and rather than the analogy being the discharge of obligations in England, it was the law of Jamaica which sustained the relevant liability and could therefore discharge it. So it's not the right analogy. And then a further case relied on by my learned friend is Starwoski, which is in the Authorities Bundle, Volume 2 at tab 12. And the case concerned the validity of a marriage celebrated in Croydon in 1950, and the question arose as to whether the wife was already married, which depended on the validity of a marriage she previously celebrated in Austria. The original ceremony took place in May 1945, but wouldn't have been recognised because Nazi law didn't recognise religious marriages. In June 1945, so a month later, the law was amended to validate religious weddings from the 1st of April 1945, so retrospectively, provided that particulars of marriage were registered. The particulars, however, were not registered until 1949. And the House of Lords held that the relevant question was whether there had been a valid marriage by the time of the second marriage in 1950, and by that time particulars had been registered, so the answer was yes. And so, again, it's not concerned with retrospectivity. It's simply, the question was whether English law marital rights were acquired in 1950, and that turned on whether an Austrian marriage had already come into effect by then. And indeed, one of the judges, I think it is Lord Cohen, at page 443, and that's at page 178 in the top left-hand corner of the report, says in terms that he expresses no opinion as to the consequences which might have ensued if the ceremony at Croydon had taken place before the order of the Austrian Provisional Government had come into force, or before the ceremony in Austria had been registered. So it doesn't assist, and
Where are we?
it is at page 447, which is right at the end of the case, my lord, 182 of the law report.
Yeah.
So none of these cases are apposite to show any undermining of Lynch, and indeed this case does not doubt the correctness of the decision of Lynch. It simply says in places that it's not applicable on the facts, which it wasn't. And then finally, my learned friend relies on a number of cases which are not concerned with any form of retrospectivity. They're instead concerned with the prospective discharge of a contract. And that, by way of example, is Helbert Wag, which is in the authorities bundle at tab 13. And that was a prospective discharge which was governed by a German law. So it doesn't assist. Similarly, the policy points made by my learned friend I've answered and don't assist him either. So that then takes me to the last strand of my argument under this ground, which I'm going to take very shortly, which is public policy ECHR, which we've addressed in our skeleton argument. But if I could just outline this briefly for the court, there are three strands to this argument. First, it would be contrary to Section 6 of the Human Rights Act 1998 to apply a foreign law which contravene the bank's convention rights. Secondly, the bank's rights under Article 1, Protocol 1 were engaged in this case. And thirdly, applying well-established principles of the European Court of Human Rights, the bank's rights under Article 1, Protocol 1 were infringed because of the unforeseeable retrospective nature of the decision in Cattolica. Now, I don't understand the first of those points to be controversial, so I'll move straight to the second point. And if we could go to the authorities bundle at tab 15, please. Sorry, volume 15, I beg your pardon, tab 111. And it's page 6041 of the hard copy, 6047 of the electronic. You should have Article 1, Protocol 1. And what you see there is, as I'm sure the court's familiar, every natural and legal person is entitled to the peaceful enjoyment of possessions, and no one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law. And we cite in our skeleton the Solaria decision in support of the proposition that a signed and part-performed contract is plainly a possession within the meaning of Article 1, Protocol 1. It's a decision of Lord Justice Coulson. I don't need to go to it, but the relevant paragraph is paragraph 34, and it's in the authorities bundle at volume 11, tab 74. My learned friend says that because the swaps were void on the basis of Cattolica, the banks never had any possessions and so did not have any rights under Article 1, Protocol 1. And that is, if the court could look at, please, the respondent's skeleton at paragraph 102. It's in core bundle tab 3, please.
Paragraph.
102, my lord, it's page 92. This is the sum total of my learned friend's submissions on this point. If my learned friend's argument was correct, then a retrospective law would never infringe Article 1, Protocol 1, because the effect of it would be to remove the claimant's possessions and deprive the claimant of any protection under the convention. And we say that cannot be right. The correct analysis must be to ask whether the claimants acquired possessions under the law as it stood when they entered into the contract, and then to ask whether the retrospective law was capable of taking away those rights consistently with Article 1, Protocol 1. Otherwise, that Article 1 would be entirely toothless.
Yeah.
That then brings me to my third and final point under this heading, which is whether to deprive the banks of their rights under the swaps on the basis of Cattolica would be consistent with Article 1, Protocol 1. And the obvious answer is no, we suggest. The protocol provides the bank can only be deprived of their possessions in accordance with the conditions provided for by law, which obviously gives rise to the questions what's meant by the law. And our submission on this point is that the law does not include an unforeseeable retrospective judicial decision, because to deprive the banks of their rights by reference to such a decision would not be lawful. And I've set out the authorities in paragraph 108.1 of our skeleton. I'm happy to come back to these in reply if time if the court wishes, and if my friend says anything about them. It's not apparent to me that my learned friend actually takes any argument on this point. As you've seen, his submission is the prior point. And therefore, given the time, I won't develop this but move to ground 5 unless the court wishes to see any of these cases.
Yeah.
So, my lord, turning then to my final ground on limitation. And your lordship has the short point, which is that the judge's decision is directly contrary to the Supreme Court decision in FII. The ground of appeal arises on two conditions. First of all, if the court is not with me on grounds 1 to 4 of the appeal. If I succeed on those grounds, or I think even ground 3 or 4 alone, then we don't get here. Secondly, it only arises if your lordship dismisses ground 1 of Venice's appeal on applicable law, and uphold the judge's finding that the restitution claim was governed by English law. And then we come to this ground of appeal. And on that hypothesis, it is common ground that the limitation period applicable to Venice's restitution claim is also governed by English law. And it's also common ground that under English law, all claims for amounts paid prior to the 16th of August 2013 were time barred under Section 5 of the Limitation Act 1980, unless Venice could bring itself within Section 32(1)(c). So that's how it arises. Venice's pleaded case, as I briefly showed you, under Section 32(1)(c) was that its mistake could not with reasonable diligence have been discovered prior to the decision in Cattolica. So it's firmly on the basis of mistake and discoverability. That's the pleaded case. The second point is that Venice did not plead any alternative date, so it's Cattolica or nothing. And the learned judge accepted that case, and we suggest that he was wrong to do so. And that was really on three main bases, which I'll outline. First of all, in accordance with FII, a mistake of law becomes reasonably discoverable when a reasonable person would know enough about the possibility of there being a mistake to justify embarking upon the preliminaries to issuing a claim, or that there is a worthwhile claim. And the two formulations amount to the same thing. The important point for your lordship is that the mistake does not become discoverable only when the law is subsequently clarified by a decision of the courts. And that was the approach previously taken by the House of Lords in DMG and was overruled in the recent case. The second of my points is that on the evidence before the judge, Italian local authorities began to challenge the validity of interest rate swaps long before the decision in Cattolica, including by litigation in England, as my Lord Justice Flo observed yesterday. And the arguments put forward in those cases were many of the same arguments that Venice has put forward in this case, some of which ultimately found favour with the Supreme Court in Cattolica. And on that basis, applying the legal principles in FII, it is plain that the mistake was reasonably discoverable long before Cattolica was decided.
It's odd, isn't it? Because on the judge's findings, it was not discoverable, but nevertheless, Cattolica was unforeseeable. There's a tension there, it seems to me, in what the judge has said.
There is a tension, except on the tests in FII, which I'll show you, reasonable discoverability is not to be equated with foreseeability. And that's the ultimate answer to that point. I think I fully accept that.
Well, that was exactly the argument that failed in FII.
Exactly.
What was said was, well, we couldn't possibly have known until the law was made absolutely clear.
Exactly.
And their lordship said, no, that's not the right approach at all.
That's not the right approach at all. And so once one has in mind that Cattolica could have been unforeseeable, i.e. the fact the Supreme Court made that decision was unforeseeable, that is not the same as saying, was it reasonably discoverable, the possibility of a claim on this basis. And in this case, it couldn't be more clear-cut in a way, because there were so many claims on this basis. And that's really the point. I'll show you the case, but that's the submission. The third of my 3 points, though, is that where the judge fell into error is that he tied the date of discoverability to the date when the mistake was confirmed by the Supreme Court in Cattolica. And exactly as my Lord Justice Flo has said, his judgment actually makes the very mistake or error that was said in the Supreme Court decision not to be the right approach. Just couldn't be clearer in this case. And he wrongly equated the question whether the outcome in Cattolica was foreseeable in the sense that it was likely to occur with whether the mistake was discoverable under section 32(1)(c). So with that introduction, may I turn then to the decision? It is in Authorities Bundle tab 81. And if my lady's looking for it in hard copy, I think that's volume 12. So your lordship will be familiar with the facts of it. It concerned claims for restitution of tax that had been levied in breach of EU law, and the invalidity of the UK's tax system was confirmed by the ECJ many years after the payments were made. And the taxpayers argued on the basis of DMG that time ran from the ECJ's decision, because until then they didn't know whether or not they were mistaken. And in essence, the court held that that was not right. And the majority decision was given by Lord Reid and Lord Hodge, with whom Lord Lloyd-Jones and Lord Hamlin agreed. The minority, interestingly, Lord Sales and Lord Briggs, went even further and held that section 32(1)(c) does not apply to a mistake of law at all. So if we could just start with page paragraph 167, which is on page 4859 of the hard copy bundle and 4865 of the electronic. Sorry. And it's paragraph 167 at the bottom. So in this section, DMG, which is Deutsche Morgan Grenfell, see that from the heading in 165, the analysis of the law is set out, and Lord Hoffman's quote was the previous basis of the law. And you see Lord Walker agreeing in DMG at paragraph 170.
Yeah.
Albeit for the possibility of a mistake was the wording used by Lord Walker. If we then go, please, to paragraph 178, their lordships here deal with a principled objection to DMG. And again, at the very bottom of this page, and just near the bottom of the paragraph, you see the words, to the extent of knowing that there was a real possibility that such a mistake had been made and that a worthwhile claim could therefore be made on this basis. So the test is not one of likelihood of success. A real possibility is enough. And in some cases, the evidential inquiry contemplated by this paragraph could be a difficult one. In others, it might be more straightforward. For example, if everyone else in the market makes the same claim. And indeed, that was a point made by Lord Brown previously.
Presenting in DMG.
So if we then go to paragraph 180, you see the dissent from Lord Brown. And Lord Reid and Lord Hodge consider the minority judgment here, and their ultimate judgment accords with Lord Brown's minority judgment. And then if we go through to 184, there's the references to they needed only to know facts which amounted to a prima facie case, right at the end of the quote. And then the ultimate conclusion is in 186. And thereon, at paragraph 187, Lord Reed and Lord Hodge consider a parallel with sections 11.4 and 14.1 of the Limitation Act, which also depend to some extent on whether the claimant could reasonably have known the facts forming the basis of their cause in action in tort. And if one looks in particular at paragraph 188, you can see the conclusion. Mere suspicion is not enough. In order to amount to knowledge, a belief had to be held with sufficient confidence to justify embarking on the preliminaries. If we then go to paragraph 192, you see that what they consider is it's consistent with principle because the limitation period normally begins to run on the date when the cause of action accrues. It's not postponed until the claimant has consulted a solicitor, carried out investigations, and is in a position to plead a statement of claim. And one drops down, there may be many matters which have to be investigated, and that may take time. Dropping down again, nevertheless, the limitation begins to run on the date of the accident. That's the example given. It is not postponed until he has completed his investigations, and these are the crucial words, or until he knows his claim is guaranteed to succeed. If you then please read paragraph 193. And we're then going to paragraph 210. So based on 210, there are two points to be made. First, where payment is made on a particular understanding of the law, time starts to run from the point when the reasonable person would know the payment was legally questionable, which is not the same thing as knowing the legal argument would succeed at the end of the day. And the second sentence makes it clear that the burden of proof here was on Venice, and any doubt about the date of discoverability should be resolved against Venice. If we then go to paragraph 213, there is a very helpful then summary of the position. And you see where the court reaches. So limitation periods set a time limit for issuing a claim, which begins when the cause of action accrues. They apply whether the substance of the claim is disputed or not, and regardless of whether there is in truth a well-founded cause of action. Section 32 postpones the running of time in cases where the claimant cannot be reasonably expected to know at the time the circumstances giving rise to the cause of action. Its effect is that the limitation period commences not on the date when the cause of action accrues, but on the date when the claimant discovers, or could with reasonable diligence discover, the mistake. Consistently with one above, section 32(1) cannot be intended to postpone the commencement of the limitation period until the claimant discovers or could discover that his claim is certain to succeed. Consistently with one above, the section cannot be intended to postpone the commencement of the limitation period until the proceedings have been completed. In tying the date of discoverability of a mistake of law in section 32(1) to the date when the truth as to whether the claimant has a well-founded cause of action is established by a judicial decision, the decision in DMG contravenes 3 above and is therefore inconsistent with 1 above. In tying the date of discoverability to the date of a judicial decision with the consequence that the limitation period for issuing a claim may not begin to run until the proceedings have been completed, the decision also contravenes 4 and 1 above. And then the court goes on to say you can't tie the date of discoverability to the date of a decision, the court of final jurisdiction, i.e. the Supreme Court in Cattolica. And in doing that, it has the illogical consequence that mistakes are not discoverable by a claimant until after he has issued a claim on the basis of a mistake. And that seemed to be at the nub of the concern here. So it frustrates Parliament's intention in enacting section 32, is inconsistent with the authorities on fraud and inconsistent with the position on the other aspects of the Limitation Act. And it's also inconsistent with the meaning given by courts to discovery in another statutory context. And then if I could ask you to read, please, 13 to 18, you'll see that the point is squarely in line with my submissions on this point. We could then, when Your Lordship's finished, move to paragraph 255. And I'll emphasise 3 points and then let the court read it. This paragraph makes clear that, first of all, a mistake is plainly discoverable at the latest when a claimant discovers that someone else has made a claim with potential implications for its own position. And that was what Lord Brown held in DMG, and his reasoning was endorsed here. Secondly, a mistake may in fact be discoverable at an earlier point in time if a reasonable person in the claimant's position could have reached the same conclusion before the other claim was commenced. And thirdly, it is irrelevant that the claimant itself was inclined not to pursue the same claim and preferred to wait and see what happened. So if I could just let the court read that paragraph. briefly refer the court to two further subsequent decisions which have considered what is meant by the worthwhile claim test. The first is the well-known Gemalto case, which is in tab 83 of the authorities bundle, same volume 12. And the case concerned the point in time at which a cartel was discoverable under section 32(1) of the Limitation Act. The lead judgment was given by the MR, and the relevant paragraph is paragraph 39, and that is page 4933 of the hard copy and 4939 of the electronic version. And after 39, if we could then move to over the page to paragraph 45, please. In fact, it's 45 to 47 inclusive. So just to pick it up at 45, you see the words could have a reasonable belief in a case of this kind on line 4. The word could is important. The claimant does not have to actually believe that they will likely establish the existence of the cartel. In paragraph 46, the standard of pure speculation at the end of the paragraph is a very low standard. And then 3 points arise out of paragraph 47. First of all, time starts to run from when the claimant could start investigating the claim, not from when it completes its investigations. Second, the limitation period is not postponed until the claimant can show it is more likely than not to succeed. The balance of probabilities has nothing to do with the test under section 32(1)(c, nor is there any scope for a complex balance of the chance of success. That submission was specifically rejected. And then thirdly, if the claim could be struck out as not disclosing a cause of action, that would be different, but that is a very low bar. The other relevant case is the Jazztel case, which is in tab 135 of the authorities. I don't think I need to take you to it, but it simply makes the point that in this case, the fact that there was no more than a marginal belief was enough to issue the claim. So it was useful to see the standard. So can I then, having set out the law, just turn to my second point, which is how those principles apply to the facts here. The starting point is that the Cattolica litigation started in 2007 with a local authority putting forward a legal challenge to the validity of the interest rate swaps entered into by local authorities. To put the matter beyond doubt, in October 2008, Venice was specifically consulted about whether certain swaps could be cancelled, and we can see that in the supplementary bundle volume 2 at tab 50. it's paragraph 3, where Venice was asked to consider whether certain swaps could be cancelled on the basis that they were speculative. And the letter refers to litigation in England and Germany. And we say that even from this point, Venice had the opportunity to begin investigating the preliminaries of issuing a claim. Then the Cattolica claim, obviously, itself was brought, and it succeeded in the Court of Appeal of Bologna in 2014. And that's, you can see that, I'll give you the reference, it's in the supplemental bundle, volume 2, tab 37. So at that point, you had the Court of Appeal successful decision. The litigation in Italy, as the court knows, prompted litigation in England, some of which may not be fairly described as a serious legal challenge. For example, I think the point's taken about the Piedmont decision, that it wouldn't be classified as such, even though it was a decision of the Court of Appeal. But as my Lord Justice Flo raised yesterday, there was, of course, the Prato case. And the Prato decision did raise many of the same points, which is fatal to Venice's case. So can I just show you then the Prato case so that we have looked at it? And that's the first instance decision is in the authorities bundle at tab 61. It's volume 9 if anybody's a hard copy. And I'll just to pick up on one correction from yesterday, my Lord Justice Flo put to me, I think at page 11 and 12 of yesterday's transcript, that the arguments succeeded before Mr Justice Walker, and I noticed that, and these are the, I think Your Lordship may have had in mind arguments based on 1196 and that they were, I said they were reversed on appeal. In fact, only the argument on mandatory rules succeeded before Mr Justice Walker, and the arguments based on Article 1196 didn't succeed before him. But what is clear for these purposes, which is relevant, is that arguments were made about both indebtedness and speculation and the construction of Article 1196 before Mr Justice Walker in these proceedings, which commenced in 2010. You can see that from the folio. And the trial was in 2014. And if you look at page 3479 of the hard copy and 3485 of the electronic. 3485 of the electronic.
3485.
I think we're looking for, I'll find the paragraph, I think it's paragraph 15.1 I'm coming on to.
That's the start of the case.
Yes, sorry, it's paragraph 15.1 I'm trying to get to, which is 3483 of the hard copy and 89 of the
Swaps
electronic.
are null and void in English law by reason of lack of capacity.
Exactly. So capacity was an issue. And then if we go to paragraph 143, you see here, did the swaps contravene Article 119? And Article 1196 was squarely relied upon, and you can see Prato's case summarised in paragraph 144. And the reference to the Court of Appeal of Bologna, it is the decision in Cattolica that was upheld by the Supreme Court in Cattolica. And if we could then go to 157.
Yeah.
Mr Justice Walker held that the Court of Appeal decision in Cattolica didn't represent Italian law. Now, of course, we know that it went the other way, but what matters for the purposes of section 32(1)(c) is that the issue was in play and local authorities were issuing claims on this basis. And indeed, Venice had been contacted about their swaps and was aware of this litigation, certainly English litigation, well before this. If we then go on to 203.
Well, your point really is if the Commune of Prato could raise the point, then so could Venice.
Exactly.
It's as simple as that.
And it's as simple as, and that's the Lord Brown point. If somebody else is issuing a claim.
Somebody else is making the same argument from 2010 onwards.
That's right. And if you go to 203, you see the same arguments on speculation. That's paragraph 203, and in the Court of Appeal, which is in the same bundle at tab 65, the conclusions on Article 1196 were appealed. The argument on speculation was essentially that Mr Justice Walker had been wrong not to follow the decision of the Court of Appeal in Cattolica, and the appeal failed. And the relevant paragraph is 45. So 45 sets out 119 and 63 is the decision. So may I just summarise then to end on this ground how the principles should have been applied and why the judge got it wrong. First of all, the relevant question is whether a reasonable person in Venice's position would have known enough to embark on the preliminaries to litigation, or that it had a worthwhile mistake claim before the decision of the Supreme Court in Cattolica. And that's the only point being Venice's case, that's the discoverability date. Secondly, a reasonable person in Venice's position did not need to know that its claim was likely to succeed. It needed only to know that others were bringing a claim, the Lord Brown test, and that there was the ability to plead a proper case, which there plainly was here. This case went to a full trial and to the Court of Appeal. Thirdly, and this is the point, the threshold's plainly reached when somebody else makes a serious legal challenge. Fourthly, on the evidence before the judge, it is plain that time started to run long before the decision in Cattolica of the Supreme Court. And fifthly, since Venice hitched its wagon entirely to the date of the Supreme Court's decision, that ought to have been enough to dispose of its defence under section 32(1)(c), it being fundamentally flawed in law following the FII case. And if we just look finally at the judge's judgment on this point, at paragraph 3 316, he starts, and it's really paragraph 429 onwards is the relevant section. And that's page 316 of the hard copy bundle. So the judge cited the relevant paragraphs, both focusing on the worthwhile claim. And then in paragraph 430, he applies the test to the facts. It's very short reasoning. And there were 3 errors in the learned judge's reasoning. So first of all, as is apparent from 430's little Roman 3, the learned judge wrongly focused on the likely outcome of litigation in England. A claim, however, is not worthwhile only if it's likely to succeed, and he therefore asked the wrong question, which should have been whether Venice could have pleaded a proper case, and he therefore applied the wrong legal standard. Secondly, as is also clear from that paragraph, the judge focused on the likely position in England after the Prato case. And again, that is wrong because it was the wrong time at which to assess discoverability. Time began to run at the very latest from the moment that a person would have known that a serious legal challenge had been made, which is long before the Court of Appeal in Prato. And then thirdly, in 430 little 1 and little 2, the judge attached significance to the fact that England was the contractual forum for the resolution of the dispute, which makes, in our respectful submission, no difference to the application of the test under section 32(1)(c). Venice's defence was always going to be based on Italian law wherever the case was litigated, and the English courts were always going to look to Italian law to assess the defence. So, my Lord, one
It
can
would be
see...
relevant to consider, I mean, potentially, what advice an English lawyer would have given if these Italian law facts had been brought to them. For example, if the English lawyer had said, well, this is hopeless, such and such a claim has got no chance, it will be struck out. Because the question is whether there was sufficient to bring proceedings in England.
Yes, my Lord, but in a sense, it seems even less likely because it's very hard to see in a claim in England based on Italian law would ever have been struck out. So query, it might be relevant, but it's not going to go anywhere because it would be very difficult to give that advice.
Yeah, well, I see.
Well, especially if people were giving, especially if other cases were already on foot.
Exactly. But foreign law would be it's quite difficult to say.
Yeah,
It doesn't
understood.
disclose a cause of action. And with no disrespect to the judge, the reasoning in the paragraph doesn't do justice to the decision in FII. So I think it went badly wrong on this topic. So, my Lord, that takes me to the end of the grounds of appeal. I'm just over, so I've not done too badly with thanks to the court for starting a little bit earlier.
If you were wrong on the cross appeal and it's Italian law rather than English law, is it a 5-year or a 10-year period? And is it right there's no equivalent of section 32 under Italian?
There's no equivalent, and let me just check on it's 10 years, but there's no equivalent of 32.
Yeah, okay.
So it does make a difference.
Mm.
So if I can be of any further assistance to the court.
Mr. Lane. Yes, Mr. Cox.
If it please you, my lords and lady, I'd like to begin by making a few general points, if I may, and forgive my voice, it's decided not to cooperate today. And then I will turn to each of the grounds in turn. So there are 5 general points. The first is that in our submission, for reasons I will develop, what went wrong here under Italian law was that the bank swaps, that's what I'm going to call the transactions in this case, they exposed Venice to paying interest on the swaps at the floor level in those swaps, which was potentially, and in fact, far above what it received to cover the bond interest. And the level that that interest would be was, of course, an unknown, and the swap was therefore speculative under Italian law. Second, for this purpose, under Italian law, you look at the bond which was issued and the swap, and you don't look at any previous swap. If that were not the case, you could end up in a position where there's a previous swap which is closed out, it is speculative, and the new swap maybe isn't more speculative, and the new swap is not controlled at all by Article 119. Thirdly, we say that we do not maintain that any negative mark-to-market is speculative, or that no swap can be restructured. It all depends. If the swap ends up being exposing the swap buyer, the person in our position, to a bet on interest rates. In some cases, the bank's margin may not be enough to make the swap speculative. In this case, the negative mark-to-market from the rollover was very significant. Fourthly, it's not common ground, despite what Milena Trent has said, that Venice had capacity to enter the swaps when it did. It is common ground that it thought it did, but the effect of Cattolica was that it did not all along. That was a decision which stated what the law was based on Article 1196, which originally dated from the Constitution of Italy back in 1947. Fifthly, it's wrong to suggest in our submission that this court should treat the Bear Stearns swaps as hedging or compliant. In our submission, the court made no finding about that, despite our late application for it to do so. And it's certainly not been admitted. It's therefore not something about which any assumption can be made. We would also add that it is not relevant either because of the first point I made.
Your second point was that you look at the bond and the swap and not at a previous swap, because otherwise there could be problems if the previous swap was speculative, which
yes.
rather sounds as if it might be relevant to look at that question.
Well, it's a possibility. That's why I put that. The second point, the point that my lord just made is it's a possibility, but it's a real possibility. It's not one I'm relying on in this case. I don't need to rely on it. But what it tells you is that it can't be right, among other reasons, and there are a whole host of reasons, but among other reasons. It's a common sense reason why it can't be right that you, for the purpose of applying 119, you look at whether the swap that's relevant in some way would sort of increased existing risk under an existing swap. The last scene setting point I wanted to make is this, and I'm very conscious as I make it that we will, and I wish very much to get on to submissions about individual points on Italian law, and it will be necessary to look at each one of them and consider the application of the standard. But it is, I would submit, useful for your lordships to see the scene in which this trial took place. The decision that was made by Mr Justice Foxton was known to be an important one well before it was given. In Cattolica, the court in Italy, the Court of Cassation had sat in joint divisions, specifically because of the importance of the case as recognised in Italy. And then, for the first time in the Busto decision, the English court had accepted in principle that Cattolica meant that a local authority under Italian law didn't have capacity, and under English law didn't have capacity to enter a speculative swap, although the claim in that case failed, largely because the speculation case hadn't been pleaded. So this was the first case after Busto when the issues of capacity came to trial in England after Busto. Now, at the trial, and as I say, we will look at specific points, but at the trial, the judge heard expert evidence from 2 law professors on each side, one civil and one administrative law. There were some 869 pages of expert reports, over 9,000 pages of exhibits of Italian law. The evidence of those experts was given over days 6 to 11 of the trial. And what I would just for the moment seek to draw from this is that the importance of the issue and the importance of Italian law evidence was very well recognised. And this was reflected in my submission in the thorough and careful judgment of the judge on Italian law issues as well as on English law issues. That's all I wanted to say by way of scene setting. Now, I just wanted to turn briefly to standard. And I do that, and I recognise, of course, your lordship's very familiar with the cases. I do it because I just want to flag some references, which I believe I submit are very helpful to your lordships to have in mind, and also because of some of the submissions that have been made on the other side. Now, first of all, we would say that the phage approach is to ask, in relation to the facts, was there some flaw or error in the treatment of the issue by the judge, which made the decision plainly wrong or rationally unsupportable? And that approach applies to findings of fact and evaluation of the facts. And in relation to foreign law, where the law is is the buyer's end of the spectrum, at the end of the spectrum where the English judge isn't bringing to bear his familiarity with English practice to the decision on the foreign law, then the phage approach applies to the ascertainment of the foreign law and to its application to the facts. And I would just briefly make that good by showing you 3 of the authorities. Phage, first of all, which is tab 59 in the authorities bundle. Yes, so volume 8, and I think in your lordships, in the courts, authorities bundle. And so the question in this case was whether or not the yogurt, called Greek yogurt, could be applied as a label to yogurt not made in Greece. And it's paragraph 114, my lords and lady, 114, page 3442. So in the judgment of Lord Justice Lewison, appellate courts have been repeatedly warned. It's just these few lines here. By recent cases at the highest level, not to interfere with the findings of fact by trial judges unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts. And then over the page, paragraph 116, I would just note if you just read the first half of that paragraph, you'll see the judge heard evidence over 7 days and read a mass of material. I'd therefore be most reluctant to disturb any of his findings of fact, whether primary or evaluative, unless compelled to do so. And my lords, just towards the top, I've just missed Little Roman 4. In making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. Mm. So what we draw from this is that the phage approach applies to findings of fact and evaluation of the facts. The judge will have had regard to the whole of the evidence. It's difficult for the Court of Appeal, particularly with the body of material there was at this trial, not to island hop. And where the judge has heard very substantial evidence, the court is slow to act, whether on primary fact or on evaluation. Now, my lords, the second decision is Volpe, tab 85, which is volume 12. Tab 85. Another Court of Appeal decision. And the question in this case was simply whether a transaction was a loan or a gift. And you see that from the first page at the bottom there. And then if you would turn over to the second page of this report, paragraph 2, at Little Roman 3, this is Lewis and LJ again on appeals on fact. Little Roman 3, an appeal court is bound unless there's compelling reason to the contrary to assume the trial judge has taken the whole of the evidence into his consideration. The mere fact that the judge doesn't mention a specific piece of evidence doesn't mean he's overlooked it. And then dropping down, if I may, to paragraph 4, similar caution applies to appeals against the trial judge's evaluation of expert evidence. And he's talking there about the buyer's end of the cases. And then lastly, if I may, Perry and Lopeg, which is in tab 87, in the same bundle.
Yeah.
And this was an appeal from the Cayman Court to the Privy Council, and the question was whether share transfers were void, and that depended on Israeli law and Liechtenstein law. and there was a 7-man Privy Council. And then paragraph 12, page 5081 in the printed, that may be 5087 in the electronic.
Yeah.
And towards the bottom of that paragraph, Lord Hodge quotes MCC proceeds, and you've got the quote at the top of the next page. When and to the extent the issue calls for the exercise of legal judgment. And you can read the rest of that quotation. And it goes on, the important words are to the extent, and the reference to familiar principles and legal concepts. And then the next sentence, the court went on to state that it was not entitled to substitute its own view for the view of the trial judge when there was acceptable evidence to support the judge's finding, unless the English court interprets the statute in accordance with the English rules of construction, and there's no evidence that different rules would govern the foreign court's construction of evidence. That the words would have a special meaning in a foreign context. Of course, that decision was about construction of a statute. And then in paragraph 13, Lord Hodge refers to the case where you've got foreign law in a foreign language, and he refers to the Byers decision. And then towards the bottom, about 6 lines up, you've got, in reaching that view, the court had regard to the foreign language of the authorised texts, the fact that concepts and principles of Saudi Arabian law were far removed from common law. And then a little bit lower down, the fact that the judge at first instance had depended on the assistance of extensive expert evidence to explore and explain the many Saudi Arabian court decisions to which the experts referred in support of their contentions. And so those are the considerations Lord Hodge is emphasising in relation to the Byers type of case. And then paragraph 15 on the next page, if I may, it's the penultimate sentence. In such cases, so it's talking about the Byers type of case. You can see that in the preceding sentence. And then it goes on, in such cases, the court at each level of the hierarchy is dependent on the written and oral evidence of expert witnesses, tested by cross-examination. Trial judge's findings on the content and application of foreign law have a close kinship to other findings of fact. And in that circumstance, the first appellate court will be slow to intervene. And the judge's assessment and the board's practice should, in relation to concurrent findings of fact, should be adopted. So, just in relation to that last passage, content and application of foreign law is what I would emphasise. So those are the authorities I wanted to just flag. And just to finish this, what we say is that this case, for reasons which I will come on to, but you're obviously aware of, depends very much on Italian law. One does look at each particular issue, but it is in our submission in almost every respect at the Byers end of the spectrum.
Sorry, I'm afraid I didn't hear that.
It's the Byers end of the spectrum. Your voice is tending to drop slightly.
I'm so sorry. Yes.
I know you've got a problem. Also, for some reason which I've now managed to discern, that side of the court has got a sort of slightly curious acoustic.
It's my fault. It's my fault, my lord.
Many advocates struggle with.
So with
That's
that,
my hearing, I'm not sure which, but I think it's probably the
no,
former.
it's not. It's
No,
not.
the point you were making was the perfectly understandable point that given that Italian law is a civil law system, not a common law system, the judge can't bring to bear in the same way as he would, for example, in relation to a case involving issues of, say, Cayman law or Bermudian law. He can't bring to bear common law concepts in his own legal judgment in assessing the expert evidence of foreign law. If it's, as it were, civil foreign law, then it's effectively, as you put it, the bias end of the spectrum.
And he's very dependent on the experts. And I'm not going to give evidence, but it was a very difficult task to get on top of all the different concepts that are being deployed. And that, I think, will come out as we go through the points. That these concepts, which are crucial to issues like that of capacity and the understanding of Cattolica, were self-evidently difficult, and they didn't get easier the more you got into them. Now, ground one, if I may, turning to the specifics, speculation, three introductory points. Firstly, in our submission, as I've indicated, the main point of contention here between the parties is whether, when asking if a swap is speculative, you compare the position of the swap buyer, that's us, Venice, with its position under any ongoing underlying risk, or you bring into account another closed out swap. And we say that under Italian law it is clear it's the former, and the judge had material on which he was entitled to base that view. The second thing we say is that much flows from that basic point. Firstly, you don't need, for speculation, to look at the risks that were under the closed-out swap. When you're considering speculation in relation to a particular swap, you look at that swap. And you ask, is this a hedging swap or is it speculative? And you look at any existing risks that may or may not be protected by that swap, if it's a hedging swap, or in some way need to be brought into account when you're considering the risks under the swap. What you don't do in our submission is ask yourself, well, is the swap buyer better or worse off having closed out one swap and entered into another? The swap buyer may or may not be better off, but whether he is or isn't doesn't answer the question whether the swap that is relevant and you're asking about, the new swap, is speculative. The second thing to flow from the fundamental point is that the question of correlation, high or not, has to be considered as between the relevant swap and any underlying, in this case, bond or other type of risk. In some of the cases we see loans. And the key point in this case was that there was no high correlation on, or indeed other correlation on one key point, which was the floor on the bank swaps, because that wasn't matched by anything in the bond. Venice would have to pay the floor amounts if the rates went against it for potentially a very long time. And that was the crucial point why the bank swaps in this case were speculative. And the third thing that flows from the first point I made, the fundamental point, is that the question...
So does that mean that any swap with a collar, as we have here, would be speculative if the underlying instrument didn't have a collar, but was simply interest was payable with a margin over Euribor or whatever it was?
It would depend, but it might well be, but it would depend. You'd have to look and see if that was capable of sensibly protecting the underlying.
Well, it's difficult to see how it could.
It's difficult to see how it could be, yes.
I mean, it really amounts to saying any swap with a collar in it, so you've got a floor. If you end up, because one's looking at it the date when it's entered into, if there's a risk that you could end up paying above the odds, as it were, and being out of the money for a long period of time, then that's speculation if it's not reflecting. If you're not protecting something specific in the underlying instrument, which by definition you wouldn't be normally,
But
unless it's back-to-back swaps.
It's not just a collar, it would apply to any floating fixed.
It would do. So if I could just stick for a moment, my lady, with the collar. I mean, in some cases, you have caps which are valuable, and as valuable as the floor. And it may be that it actually is overall not a risky investment, and it may be neutral as regards the underlying.
By definition, any collar, any swap with collar in it, if the market goes a particular way, if the interest rates go up, then it's going to be an advantage to the buyer, isn't it? And that's the whole point of protecting yourself against interest rates under the underlying instrument.
But depending on, my lord, yes, and depending where you set your cap, it may be that you've got protection that you consider meets the risk that you equals the risk that you face on the floor. I mean, in this case, the cap was very much less valuable than the floor. And that reflected the fact that the floor was so high. The forward curve was below the floor when it was sold. So it was, as far as estimates go, known to be loss-making from the very beginning. That wouldn't necessarily apply. But but this proposition does flow in my submission from. It all stems from the approach of the law in Italy. My lady raised a point about floating rate.
Well, I meant if you swapped, you had a floating rate on the bond that's here and the swap fixed, that equally you're taking the risk that floating
Yes,
rates will in fact
absolutely, yes, that would be a sort of plain vanilla risk.
But a similar point applies, doesn't it, in principle?
Yes, yes, the approach of the law in Italy at the time was that it didn't want local authorities to be taking on speculative risks. And we see that developed in Cattolica, the idea that in their nature, derivatives are chancy, aleatory, chancy. They, because they're based on future interest rates, which nobody ever knows, unless you're very, very careful with them, then you've got a risk which is inconsistent with the approach to public finances in Italy. And we'll see that in Cattolica when we get to it. Of course, Cattolica did allow local authorities to enter into swaps, provided they weren't speculative.
You've made the point that you have to compare the position of the swap with the position on the underlying risk, and that seems pretty straightforward if you look, for example, at the consult rules and so forth. But did the experts squarely confront your corollary, which is that you do not bring into account the position under another closed-out swap and compare the swap buyer's position before and after?
My lord, I can't give you chapter and verse, but I will give you chapter and verse on that. Yes is the answer. That is my answer at any rate.
That might be quite important because you say this is a fundamental point, and
it
does seem to be. Mr. Loney says the opposite. So it might be quite useful to see whether that was a point which
yes, I'm just struggling to give you
confronted, and then the judge made his decision based on that evidence.
Yes.
Yes, all right. Well, we'll come back to that if you
Yes, in fact, I think it rather went the other way. I may say so at trial. What we weren't there weren't submissions being made on behalf of the banks that in relation to speculation you ought to be taking into account the closed out swaps. But if I may, my lord, I will come back to that. I'll come back to the how the evidence stood on each side.
Well, you've got
but
a
it was-
point, which is the point I think you make in Scholars, which I see considerable force in, which is that if the original swap is itself a speculative swap, it's no answer to cancel it out and enter into another one, which is also speculative. You can't, as it were, otherwise you escape simply by cancelling out the first swap and entering into another one. When I say you escape, I mean the banks do. But the position would be different if the original swap wasn't, as it were, impugned in any way. And that's the point that Ms. Tullaney makes. She says, well, the original swap wasn't being impugned. And what was happening here is that Venice were in a hole, and they had to be dug out of the hole, and this is the way in which they were dug out of the hole.
My lord,
I mean, I can see considerable force in that argument that says in considering whether or not the second swap is speculative, you have to look at the overall picture, which includes the original position. But if you're telling us that the Italian law evidence was you ignore the original position and the judge accepted that evidence, well, then that's probably the end of ground one.
Yes, my lord, that is my...
Well,
that
we
is
need
my...
chapter and verse on that, Mr.
You will,
Collins.
yes, and that is my submission. And it's, as your lordships, I can tell, appreciate, this is very important. This is the fundamental difference between us. And it underlies many of the other
Well, you were
points.
told yesterday, and I'm not suggesting Ms. Tullaney was misleading us in any way, because I'm sure she wasn't, but we were told that the original swap wasn't, in my word, being impugned before Mr. Justice Foxton.
My
You
lord,
seem to be saying that it was.
My lord, it wasn't. We did try with a late amendment application to to make the same arguments in relation to the best and swap, but
Yeah.
we didn't succeed on that. So the net result was that he didn't have to consider that point.
Well, the net result surely is that we have to proceed on the basis that the original swap was valid under Italian law.
Oh, my Lord, no.
And it
Unless
just-
it was evidence that it wasn't.
And it just happened that the market had gone against you, so that there was the negative MTM.
Oh, my Lord, on the first point, the validity or otherwise of the bear stand swap wasn't an issue. We tried to put it an issue, but it wasn't an issue. That's my submission. So the judge has made no findings on that. I also say, in my respectful submission, it doesn't matter to the fundamental point, because the correct approach is to ask, isn't to look at the closed out swap. It's to look at the swap you're asking, is it speculative or not? And to ask, well, what other existing risks are there? And then to decide whether that swap is exposing the swap buyer to risks of the type that can be characterised as speculative. I hope I've made that clear at any rate. That's my submission. And I'm going to develop that. But at the moment, I just want to be clear about where I stand and why it's important and where it's different from the other side. Okay. My Lord, the third, my Lords and Lady, the third point that flows from the fundamental point in our submission is that the question of whether or not there is a new risk depends on whether or not the new swap is exposed to different risks from those under the ongoing hedge, the ongoing underlying hedged instrument, and what those risks are. The final introductory point I wanted to make is this, that one of the themes of Milena Trend in her submissions was that the approach in the highest courts, the Court of Cassation in Cattolica and the Council of State, in two cases, showed that there was nothing wrong with merely rolling over or having a negative MTM in a swap. And it's our submission that that's not sustained when one looks at those cases. It's not correct. They don't show that. And there is no basis in those cases, or indeed anywhere else, for a submission that, well, because you can have a negative MTM on a swap, you can have any negative MTM on a swap, however large and speculative it might be. What this comes to is that there's a world of difference between accepting that a swap which is being considered can take into account a bank's profit margin that may or may not affect whether it's properly a hedge. It may still be a hedge, even if it takes into account profit margin. It all depends on the particular swap.
Sorry, you said it's a world of difference between accepting that a swap can take account of a bank's profit margin, but you never completed what that is a world of difference away from.
I'm so sorry, my lord, from the proposition that any negative MTM rolled over into a swap is approved as it were, okay by the highest courts of the land and not speculative. So, with that, may I turn to the judgment? Bundle C, tab 9. Paragraph 187. This is page 230 or 236. I think I see that your lordships may have, your ladyship may have hard copies of this one. So this is where the judge begins to deal with the speculation argument. And he begins by considering what Cattolica decided. And at 195, I just want to begin with this. Your lordships will see, your and ladyship will see 195 little I. The Supreme Court held that the aleatory nature of derivatives contracts, as the difference between the amounts to be paid and received by a local authority under an IRS is uncertain and exposed to market risk, wasn't compatible with the fixed nature of expenditure commitments, and presumably therefore prima facie inconsistent with the need to balance income and expenditure as envisaged by 1194. And may I just take you to that part of the Cattolica decision, which is in the S tab 37, which is the second S bundle. And page 433. Paragraphs 8.2 and 8.3. If I could just invite your lordship.
Which tab?
37. Page 433.
Right.
8.2 and 8.3, if I could ask you please just to read that. And there are 2 points I wanted to draw out of this. The first point is that the in 8.2 in the first line, the court refers to derivative contracts because they are aleatory, could not per se be entered into by the public administration, because their aleatory nature is highly inconsistent with the rules relating to public finance, and the introduced variables inconsistent with the rules relating to public finance. So, first of all, aleatory is explained there. It's fundamentally, the idea is it's a chance bet. The throw of a dice, quite literally. Second, whether a swap is aleatory doesn't depend on whether it closed out any other swap. It depends on the risks that you undertake under that swap. So, thirdly, even if there was a negative MTM rolled over into a swap, the question would still be whether or not the outcome under the new swap depended on chance because of the market movements, which are unpredictable, or was not of that nature and more compatible with the fixed nature of expenditure commitments. That's the first point. And the second point is that in 8.3, one sees at the top of page 434, the distinction between hedging and speculative derivatives based on the criterion of the different degree of risk of each of them meant that only in the first case could a local entity be said to have capacity to enter into them. So a hedging risk is one that a local entity has capacity to enter, and it's not speculative. And we see this distinction drawn several times in this judgment. It's a crucial distinction that is relied on. And it's inherent in a hedging swap that it's hedging an underlying risk. To be hedging, it has to protect against some risk that you face under some other transaction. Here, a bond, could be a loan. Can I also refer you, please, to paragraph 4.6 in the Cattolica judgment?
4.6.
Yes, it's. I'll just give you the paragraph because it's. Sorry, the page because it's misleading. It's page 425. Yes, there are two. So I'm moving on to another point now. This was the paragraph that Milena Trent showed you, and essentially used it to make the submission that it showed that the highest court didn't regard having a negative MTM as being something that wasn't allowed. And also that the court acknowledged that a bank could charge a fee. And I would just like to make 5 points about this paragraph in relation to that submission. Firstly, we submit, as I've just done, the correct position is Cattolica decided that a swap could only be entered into by a local authority with capacity if it was hedging. Secondly, if the negative MTM being postulated means that the swap isn't hedging an underlying risk, that is protecting the swap buyer from some risk, then it will be speculative. Thirdly, if the negative MTM, on the other hand, isn't of a size or a nature to rule out hedging, then the swap may not be speculative. Fourthly, this paragraph occurs in section 4 of the judgment. And if I could just invite you to turn back 2 pages to 423. You see at paragraph 3.1, the court says that before considering the topics referred to by the division, that's the joint, the first division of the Court of Cassation, to these joint divisions, we must expand our analysis to the phenomenon underlying this dispute. The topic of derivatives, which involves various branches of law, has been the subject of legal comment from court decisions for years, and so on. And then my submission is, I'm not asking you to read all of this, but my submission on this is that what the court is doing in this section is to describe the practice of entering into and constructing swaps as a preliminary to then considering their legal consequences. 4.6 occurs in that, and it's not any part of the analysis of the court, which we see later, of the legal consequences of the swaps. And it certainly can't bear the weight that my learned friend would seek to put on it, in my submission. It's not, in short, a basis for suggesting that any swap with a negative MTM would not be speculative, or could not be speculative. That the court wasn't engaging with that issue. It was trying, it was describing a classic brief description of how swaps work. So that's the first of the two decisions, the high decisions that my learned friend relies on in support of the submission that negative MTMs are okay and non-speculative. The second one is the Council of State decision, which is in bundle S32, which is the first S bundle. S tab 32. And the part I want to refer to begins at page 364. And can I just preface what I'm going to say by saying this, that this was a case where there was a debt restructure by the authority, and it was accomplished by paying back loans, issuing bonds, which were then protected by swaps. And one sees that at page 365, 16.3.1, which is the next page. The first phase in the overall debt restructuring process was the reconversion of the loans with 4 different banks into a new bond issue with a combination of a collar derivative. So that's what happened in this case. And the question was whether or not that structure complied with Article 41 of Law 448. And you can see that referred to on page 364. Towards the, about 3/4 of the way down, although these parts were independent, they are nonetheless connected to the internet as they're structurally geared towards achieving the objectives set forth in Article 41 of 448. For this reason, the economic convenience evaluation must be extended to the entire transaction. And we can see Article 41 is summarised. If you can possibly keep open that S bundle. Actually, it's in the same. I think it's.
I mean, this seems to be the Council of State contemplating that for the purposes of Article 41, you have to look at the entirety of the transaction, including the outgoing loans, which is the first element, the advance repayment of the pre-existing floating rate loans, which suggests that what the position was previously is relevant. At least they thought it was relevant.
Well,
It's not simply looking at the, as it were, at the where they are now in terms of the issue of the bond instead, followed by a swap.
Yes, and my lord, that 2 points about that. One is it came about because of the wording of law Article 41, which I'm just about to show you, which required the entire transaction to be economically convenient. And the second thing is that this case isn't talking about a closeout swap. It's talking about the conversion of the underlying loan into a bond, so that you're looking at the net position, the ongoing net position of the swap buyer on his on the money he owes to lenders or bondholders against the swap. So, my lord, I was just going to show you. Tab 9, and then jump back to that case actually. But tab 9, if you just want to see Article 41, well, a summary of it actually. We don't, I believe, in here have the actual article, but this is from the expert report of Miss Alibrandi, paragraph 55 on page 80. So this is tab 9, page 80, paragraph 55, Article 41. And if I could just invite you to read 55 and 57. So your lordships will see this is a provision that required if you're entering into a debt restructuring arrangement, you had to ensure a reduction of the total financial value of the existing liabilities. And it allowed you, as part of that, to underwrite an interest rate swap, which had not a purpose of amortization of the existing debt. I'm sorry, I've got that the wrong way around. You were forbidden from underwriting swaps which didn't have a purpose of amortizing the swap, the debt, or were not economically advantageous. So it's a very different exercise that the Council of State was involved in. And what they, if we just go back to the Council of State, tab 32, page 365, what you see at the bottom of page 365 is that the advantageous effect of the conversion of the loans into a bond was estimated by the consultant at €402,000. And they say for this reason, the consultant made it clear that this value corresponded to the threshold within which any implicit costs inherent in the derivatives were to be limited for the purpose of the overall economic convenience of the debt restructuring. And then finally, you see page 368, just above the middle, the implicit cost of the swap was €320,000, which was well within the threshold of €402,000, and would not in themselves have been sufficient to lead to a negative evaluation of the economic convenience of the overall debt restructuring transaction. So that was what that case was about. It was about whether under Article 41 the whole deal was economically advantageous within the parameters allowed. It wasn't concerned with whether or not the swaps were speculative, or how you assess if they're speculative, or whether or not a negative MTM could render it speculative, or even whether or not an imbalance between the value of a cap and a floor would indicate it was speculative. So
Just to be clear, though, there were negative MTMs in those swaps that the Council of State were considering in that case.
yes, it looks like, yes, the 302,000.
Yes, in fact, it's referred to earlier in the decision, I think, the numbers as well. So you're saying, I understand your point that the decision is actually about a different article, but nevertheless, you could, another way of putting this would be, if you're effectively saying that if this court had been asked whether they were speculative, those particular swaps, it might have concluded that they were, and therefore that authority had no capacity. You're just saying the decision was on a different point.
If I understand the point correctly, if you were to apply the speculative test to this, although it's actually under a different regime, but if you were to apply it to this, in my submission...
The point of economic convenience is surely that it's not speculative.
Is it all sort of wrapped up?
Yes, it's...
Picking up on the lady's point. If this court, the Conseil d'Etat, sorry, the Council of State, it's the same concept, the Council of State had thought that this was a speculative contract or speculative swap, in considering whether the totality of the transaction was speaking on this, we might have expected them to say, well,
yeah.
it isn't, because this is speculation.
Well, my lord, the question. Firstly, the question we've addressed is Article 41, which I've shown you a summary of. Secondly, this is. It's hard to tell often with these facts because they just don't emerge the way that we say them. But so far as we can tell, it looks like it's a totally different situation from ours because it's not a close out of a swap with the NTM rolling over into the new swap. What they were doing is they were converting the loans into a new bond issue. So what they were doing was the swap buyer was altering its debt, if I can call it.
Yes.
Fundamentally, it was altering its debt.
You indicated, as you say, the facts aren't always clear. We presumably just don't know if the negative MTM in this case may have been, at least in part, attributable to some other closing out of
I don't know. I'm
swaps.
sure I'll
we
be
don't know.
I'm sure I'll be told if that is the case. I don't know.
We certainly don't know, for example, whether the negative mark to market was purely attributable to the bank's profit, which, if I understand your submissions, might be at the sort of acceptable end of the spectrum.
Yes, I mean, when one stands back and looks at this, you've got is a case where they've restructured their debt, and as a part of that, they've entered into a swap, and the debt is net positive for them, and the swap is less negative. So that it looks, so far as one can tell, as though this is one of those cases where there is a negative MTM, but it's not speculative. But what I wanted to do really was to just stand back from these two cases, which seemed to be the bedrock of, it was like these, it appeared at times in the Lenfriend submissions as though the banks are using these two cases to make the point that any negative MTM is not capable of being speculative if it's rolled over into a new swap. Now, I'll no doubt be correct if I'm wrong about that, but that was the impression I had. And then that was being used, because these are two high decisions, the Court of Cassation and the Chancellor say, that was then being used to say that contrary decisions of lower down courts were not to be given much, if any, weight. And in my submission, the basis for that is not right. These two cases do not establish the point that I've submitted was being made by Lenfriend. And that's quite important because it crops up quite a lot when we start to look at other cases which are not as high courts, from such high courts. Now, obviously we'll need to come back to Cattolica on the question of capacity, but I want now to turn to the evidence that was referred to by the judge in relation to speculation. And paragraph 203 of his judgment in bundle C, tab 9, it's the first one. Page 2, paragraph 203. The judge summarises the evidence that he's going to consider in relation to speculation. And it's evidence of Italian law, reference by Venice to English case law, and evidence from 2 market practitioners. And it was the first category he found the greatest assistance. And then 205, it was the evidence of the expert for the banks, Professor Gentili, one of the experts, that essentially Consob provided a de facto definition of hedging. And the judge then considers that. At 206, he quotes, summarises Consob, and we looked at that. And at 208, the judge's approach was that he accepted it was of assistance. It's been relied upon in a number of Italian court decisions, and he refers to them. And then he makes some further points about it. It's clearly not exhaustive. It was issued in 1999 to deal with a specific query raised by a private company in the context of various articles of the regulation.
I mean, one problem with this, at least as I see it, is that although it's no doubt describing accurately what the experts say, it's all at quite an abstract level, and it doesn't appear, at any rate from these paragraphs, that the experts expressly confronted the fundamental point, as you describe it, that you don't compare the new position with the previous position. And I wonder whether that's because they were never asked about that, or because, well, I just don't know, but it doesn't seem to me that that is addressed in these paragraphs as a specific point, which has now become the critical point on this appeal.
Two points really, if I may, on that. 3 points. The first is that and I'll have to get you chapter and verse on this, the experts were asked about what was speculative, but the point was made that that's really a matter ultimately for the judge. And I think the judge accepted that.
So the judge was given consol, he was told there are these other indicia in the cases, and you're on your own now in applying that to the transaction here.
Essentially he had to consider the materials that he was given and decide the issue. He wasn't going to be told by the experts. But my lord, perhaps I don't want to mislead you, so I would like to be able to come back to you with chapter and verse on exactly to what extent they exactly covered that question.
All right. Well, you do that when you've got it at your fingertips.
Yep. So I was just looking at the judge's treatment of this question of consol and whether it was de facto definition or something else. And 209, he makes the point it was issued to deal with a specific query by a company, and he sets out the queries. And then just below the subroman 3, perhaps I can just invite you to read that block of text above 210. So he's making the point there that it doesn't deal with the sort of swaps that were in issue in this case, the more nuanced questions. And he makes the point that there were many Italian court decisions which have addressed the issue without referring to the concept determination or applying the three-stage test. And he refers to the report of Professor Alibrandi, and that the reference is S18139, S18139. So that's his consideration of consol. He does take it into account, but it's not exhaustive or definitive. Now,
if you're moving on to something else,
I'm just,
it's
yes,
probably
I was just
sensible to break for lunch. So we'll say 2 o'clock.